everyone in every. Okay, perfect. Okay, good afternoon, everybody. Good morning to those in the Americas. It's a pleasure to have you here today on behalf of the Working Group on Identity Rights. It's a pleasure to have you all. What we know is that our moderator is having some difficulties getting in, and we will let Bina in and she will take over the moderating role. But until then, let me introduce you to our first speaker today, who's Karen Heisler, Senior Regional Advisor in UNICEF Wakaro. The biographies of all our speakers will be put in the chat function, so you can read those, and they're also on the website should you want to have that information. Today's webinar is the third in our series on right to identity and access to justice and effective remedies. It is being organised as part of a follow-up to the work that we were doing with the CRC committee as they work on the next general comment on this topic. So today we have Karen, who will be speaking to us about birth registration in emergency situations in the region. And so I hand over the floor to you now, Karen. Thank you.
Thanks very much, Mia, and good morning and good afternoon, everyone. I'm going to share several slides, so hopefully I will be able to do this. I hope everyone can see.
Yep, it's perfect, Karen.
Great. So thanks so much. And look, this is a slide that is intended to set the scene for the few remarks that I will make. Like many regions of the world, but particularly in West and Central Africa, this is a region that is heavily affected by humanitarian contexts. And many of us would have been talking about the term polycrisis. So protracted, overlapping, interlocking crises that are affecting many parts of this region, with the darker red being those countries that are most affected. And we're looking at protracted and acute conflict, displacement, acute public health emergencies, climate change, which brings about flood, and also drought. And we know, and I won't go into the details here, that emergency situations can really draw attention to how important it is to have an identity document, but it also makes us realize too that in many cases documents may be left behind, they may be destroyed. We need birth certificates, birth registration to facilitate family tracing and reunification. We also know that the actual system itself, the facilities, may become dysfunctional, may also be destroyed. So really just wanted to set the scene with this particular slide. The next slide is around migration. And again, this is a continent where, and including in the part of the continent where I'm working, where significant populations are on the move. Now, this particular slide is really about labor migration. A lot of it is informal. We've seen survey responses from the Afrobarometer, which says that many or over half of Africans have considered emigrating. We know populations are moving within countries and across borders. We know the population of the continent is extremely young and will soon, by 2050, be the youngest population and have the world's largest proportion of children in the world. And we're seeing a lot of populations moving to urban areas. Again, a context which is very important when we look at identity birth registration. So a less busy slide, really around data, guidance, and tools. So just wanted to draw attention to the latest data publication on the birth registration SDG target 16.9 that shows the latest trends and is actually quite exciting because there's been a really positive trend in birth registration in some parts of Western Africa. And, kudos in that regard to many governments in this region who have been taking steps on laws and policies and systems that also anticipate and respond to crises. And the other document that I want to draw attention to is civil registration guidelines and recommendations for African Union member states. It's a document that was produced and released in 2022, and it draws on very concrete experiences of birth registration and civil registration in humanitarian situations. And of course, we also have the UN guidelines as well. And what I wanted to do to speak to is two country examples, one from Burkina Faso and one from Chad, and looking at how these countries and the governments in these countries are taking steps to ensure that laws and policies are in place that simplify procedures, that make it easier, that ease the burden in a humanitarian context, that also put in place the institutional arrangements, including coordination mechanisms and the interoperability with health to facilitate in a context of crisis. And third, to ensure the secure storage and protection of records. Also, the importance of declaring civil registrars and those facilities as being among essential services is so important. And also linked to this piece is the whole part around digitization. Having only the record that is printed out, which is so important, but not having the system behind it that's digital can be particularly problematic when we're seeing registration facilities destroyed or access becomes a problem. The other issue is an important one we look at disaster preparedness, and also when we look at countries that are developing their national adaptation plans in climate change, is how important it is that civil registration vital statistics are considered as part of the preparation for disaster, so that we have that in place, and that they're also part of the national adaptation plans that many governments around the world are working on as we speak, in light of climate change and the various actions that are being taken around climate change governance. So Burkina Faso, this is a country that is actually doing quite well in birth registration, with on average about 81% of the population have their births registered. But it's also a country in crises with a significant number of internally displaced persons. As we speak, 2 million. The government has recognized this as an issue. It's looking at how do we have a civil registration system that works across all contexts. And they presented this actually at the 6th Conference of African Ministers meeting in Addis Ababa in October 2022. So what they're looking at, and there's some considerations around territoriality because there's a number of armed state groups working, operating in the country, but shorter term, they've put in place mobile court sessions and legal clinics to facilitate the registration of IDPs who are in areas where they're not normally from. And we've also seen that some municipal offices have been able to resume operations as access becomes possible, as security situations improve. And this is also in terms of restoring access. The other thing the government has been doing is looking at digital initiatives. They're testing some, and they're creating a centralized database. And this is to make it easier to retrieve and issue documents in the case that they are destroyed or lost, and also to be able to ensure that we have a functioning system in different types of crises. In terms of the longer term work, and these things often take longer, a draft law on civil status has been developed that is addressing and seeking to address civil registration during emergencies in these situations where populations are outside their normal residence, in situations where they may not have access to other types of documents. The law is under review currently by the Council of Ministers. And so UNICEF, UNHCR, other agencies are looking to see how we can support and collaborate in this regard. Very quickly, in terms of the learnings, one, again, just drawing attention to the importance of mobile courts in the digital system. The other one is around the legal reform. And third is around the issue of territoriality. So where you're in a situation where populations are in areas that are not under state control, this is where the mobile courts, court sessions are so important to be able to ensure populations may have access. So that's Burkina Faso, a situation where the government is looking into this and recognizing how do we have a resilient system, a resilient civil registration system that works in all contexts, including the situation where the various types of humanitarian crises, particularly conflict. Chad is the second example I want to speak to. And this is a country in Middle Africa, according to SDG tracking. It's a country that was 30% in 2000, so not particularly high. It dropped considerably down to 12% in 2015, but it has over recent years rebounded, again, thanks to the leadership of the government. And this is a country where they've done a lot of work to simplify the business process, to make birth registration less complicated, to issue the notification and the certificate at the same time to reduce the numbers of steps. And it has tried to bring the birth registration to the local hospital, to bring it as close to the community as possible, and also to allow community health workers to be able to get the birth declaration and to facilitate the certification of the birth. And the country has created a digital app, Tajdil, which means registration in Arabic. It works online and offline, and it is helping reach nomadic populations, pastoral population, of which there's a significant number of the country, and very importantly, in a country that's hosting the second largest number of Sudanese refugees. It is also an application that's being used in the eastern part of the country to register the births of refugee babies. And they're making sure that they're doing this so that they register host populations, because many of these populations in the eastern part of the country may have been underserved by existing services. Also, there's a significant number of Chad returnees with the Sudanese crisis. They're being registered, and then also the births of the refugees themselves. And a lot of work is being done to test and use this app and to see how they can use it in other parts of the country, including parts of the Lake Chad Basin region, which is another conflict-affected region, where when access is possible, they try to make sure the populations there have their births registered. So I'm going to stop there, but just to say, from the Burkina Faso and the Chad example, we're seeing strong leadership by governments looking at systems that look from the operational side to the legal and policy framework to make this possible. And of course, there will be more bottlenecks and things that come up, but the government's looking to see how they can manage that. So I'll stop there. Thank you very much.
Thank you so much, Karen. And that was really good to see that there are countries who have good practices. And I think this needs to be shared across the board with other countries, and to help, especially like the part where they have an app to actually facilitate the birth registrations. And now we move on to another speaker, and that is Zoe, who's going to be speaking. Zoe Bertrand is a senior advocacy and policy officer for the Global Survivors Fund, UNHCR, with a focus on advocating for children affected by conflict-related sexual violence. So here you're going to hear from Zoe on the impact of the lack of legal identity on children born of conflict-related sexual violence. Over to you, Zoe. Thank you.
Yes, thank you very much, Bima. I'm going to share my screen. Hopefully it will work. Is it working?
Yeah. Do you have permission to share?
Yes.
Yes.
Okay.
It's coming now.
Okay, we can see you. See the screen as well. Thank you.
Super. Thank you very much, Bina. Hello, everyone. My presentation today will focus, as mentioned by Bina, on children affected by conflict-related sexual violence and their access to legal identity. Just to start with a short introduction of the Global Survivors Fund, the organization I'm working for. This organization was launched by the Dr. Denis Mukwege and Nadia Mourad, who were Nobel Peace Prize laureates. It was launched 5 years ago now. The overall aim of GSF is to work to enhance access to reparation for survivors of conflict-related sexual violence globally, but also to ensure that they have access to reparative measures in the meantime, while waiting for effective reparations coming from governments. Access to reparation for children affected by conflict-related sexual violence is really one of our top priorities. Our strategy focuses on 3 thematic areas. The first one is education and livelihood training as a form of reparation. The second one is co-creation and other forms of participation. And the last one, which is the one that interests us today, is access to legal identity and nationality for children born of rape. Just to give you a brief overview of the situation of children born as a result of rape in conflict settings, as you know, there are significant numbers of children that have been and continue to be born of rape in conflict. We have seen instances in every part of the world. Currently, the situation in the DRC is particularly worrying, as you probably know. But in addition to the challenges those children face as a result of conflict, they have specific additional challenges, including economic and social marginalization. They have physical and psychological injury. They suffer from depression and trauma, and they don't have access to reparation. They are often perceived as children of the enemy. So they are therefore excluded and discriminated against and stigmatized. The mothers often struggle to bond with their children or may even reject them due to associated trauma of the violence they experience. So the stigma, etc., make them reject the children, but also the partner and the family or even the community pressure to reject those children is really horrendous. That's just a short overview of their realities. But one additional challenge, which is the one we are focusing on today, is the existence of multiple barriers preventing those children to being registered at birth. They are denied their right to legal identity and nationality. We have organized in June 2023 a roundtable, and following that roundtable, we published a report that contains concrete recommendations that we have identified to overcome those barriers. And offers a reflections on the challenges, good practices, and current initiatives that are currently being done to overcome the barriers to access legal identity. I will only review a few points from that report today, but I encourage you to have a look at that report, and I think the link will be shared later on, if not already. So what is the issue? Our first observation was that there are numerous legal, administrative, and practical barriers preventing children born of rape to being registered at birth. Not knowing the identity of the father, the genitor, as it's often the case for those children, it really creates a multitude of issues related to their identity, but also their relationship with their family, with their community. So that's the first concern. The second issue is the fact that the children born in conflict settings are sometimes not born in the country of their mothers, of their mother home country, and so they face significant additional barriers to obtain legal identity and documentation in either countries. So this is the case, for instance, of children born to Ugandan mothers who were kidnapped and forced to give birth so often in the DRC, in Sudan, in Central African Republic. Those children were born in the bush, so born outside of a formal clinic, and they face huge difficulties in being registered in Uganda because they do not have the legal documentation that are required to obtain a birth certificate. So that really leads to, in the end, to statelessness. In addition, countries of asylum sometimes don't apply birthright registrations to children born on their territory, which leads to those children being stateless. So that's for the case, for instance, for Syrian children born in Turkey. They are overwhelmingly denied citizenship, even if Turkey's laws allows for birthright citizenship for children born of foreign parents. Syrian children in reality are being discriminated against, and this law is not applied equally to Syrian refugees. Our third observation is the impact of the trauma of the mother, which affects her ability to formalize the child identity. And so they don't register the children because they can't overcome that trauma. I'll go quickly on the consequences of that non-registration. So basically, the non-registration, it will impact the overall well-being and development of those children throughout their lives. A legal identity is, as you probably know by now, required to access other human rights and essential services, such as access to education, access to health, access to social protection, property, in some country, inheritance. This is, for instance, the case in Iraq, where children born of rape, including children born of Daesh fighters, they often don't have access to healthcare, to education, to housing, because they don't have that civil documentation. The lack of access to legal identity further leads to increased vulnerability, exclusion, discrimination, stigmatization, and in the end, statelessness, which leads to additional emotional trauma and economic hardship for those children that already face those consequences. I would like to add that without a proof of their legal identity, those unregistered children are not visible in society. And this is particularly concerning in conflict settings, because it increases their vulnerability to abuse, to exploitation, such as to child labor, child marriage, but also they are easily recruited by armed groups. And the last obstacle I would like to draw your attention on is the fact that without a legal identity, those children often don't have access to justice and reparation and effective remedies. And because some programs require victims to have a legal identity to access them. Often justice systems require legal identity to have access to them. Additionally, because governments, when they establish reparation programs, they don't recognize children born of rape as direct victims, so they don't have access to reparation and to effective remedy. This was the case again in Iraq, for instance, when the government adopted in 2021 the Yazidi survivors law. They did not include children. They did not recognize children born of rape as direct victims eligible for reparations. So that's one of the main concerns of the Global Survivors Fund. Breaking down those societal, legal, administrative, and all those barriers I've just mentioned requires strategies that include legal reforms, obviously access to legal identity through the mother only, for instance, awareness and advocacy campaigns to sensitize around this issue, but also targeted interventions. And I'll stop here for a minute. But while some initiatives that are aimed to address the lack of legal identity for all children would obviously benefit children born of CRSV, it is important that additional initiatives specifically target this category of children because they face specific, distinct challenges. So for instance, it's essential to provide support to mothers to help them accept and recognize their children, despite it being incredibly difficult and the trauma they are facing. And it's also important to provide them with practical support to overcome administrative barriers. Helping mothers to cope with their trauma and accept the child is often a first step toward the recognition of these children. On the other hand, and that's the other side of the coin, campaigns are sometimes more effective when they not only target children born of CRSV, so broad equal nationality and legal identity campaigns are sometimes more effective. So that's why we really need to be context-specific, country-specific, culturally sensitive when we develop advocacy campaigns. So that, for instance, in Iraq, in NGOs launched a campaign in 2018 that is called My Name is My Mother's Name, to advocate for legal reform to allow for the registration of children through their maternal lineage only. And this grassroots campaign really adopted a broad approach for the recognition of the maternal lineage for all children born out of wedlock. And that was to avoid stigmatization of children born of sexual violence in Iraq, which is a big issue there. I see that I'm a bit over time, so I'll go quickly on the recommendations, and I may have some time to go back to it after. But just to mention a few recommendations, they are all detailed in the report that will be shared with you. But there are some recommendations that really apply to all children, as I mentioned. So that's, for instance, the need for governments to guarantee equal rights between men and women in the transmission of their nationality. The fact that government should also reconsider the requirement of legal identity as a prerequisite to access other rights. Let's say you don't need a piece of paper to have access to education and healthcare, concretely. Other recommendations are more specifically targeting children born of rape. For instance, the recognition of children born of CRSV as direct victims and the provision of remedy and reparation for the harm they have suffered. Access to legal identity should be included as a form of reparation in reparation programs. Also develop the campaigns, the education of survivors and their family to highlight the importance of birth registration of children is very critical, and awareness raising campaign at all levels, targeting the international community, governments, community, to promote awareness on the rights and the needs of children born of CRSV and their mothers. Putting the issue of children born of rape on the agenda will really help break the stigma they face, and is a first step towards their legal identity and their recognition. Thank you very much. I'll stop here.
Thank you, Zoe, for your intervention. And it was, mothers are so vulnerable, and on top of that, they're going to face all this challenges in getting the legal identity for their children. We really need to do a lot of advocacy around this. And first, let me apologize for the technical glitch, and I wasn't able to come in on time. My name is Bina Ramanand. I am from Family Frontiers. I work in Malaysia, and we work on marriage migration, as well as the consequences of it is the risk to statelessness when people are unable in Malaysia to register their marriages. And may I just say that we have 30 minutes towards the end of this webinar where you can ask your questions. And I would recommend that you use the Q&A function at the bottom of your screens and also identify the speaker that you would like to address your question to, right? And so I think we are still right on time. And before we go on, we're going on to our next speaker, and that is Laura. And Laura
Hi, everyone.
And Laura is from Colombia, UNHCR Colombia, and she will present Colombia's good practice and the measure of Children First, which benefits children born in Colombia to Venezuelan parents. Over to you, Laura.
Thank you, Vina. Hello, nice to be with you all. Please let me know if you are seeing my presentation right now. Yes?
We see it. Thank you.
Okay. So as Vina said, my name is Laura Echeverri. I'm from UNHCR Colombia. I'm the focal point for nationality here in the country. And I'm going to present to you this good practice called Children First. It's a measure aiming at preventing statelessness for children born in Colombia of Venezuelan parents. So a little bit of context. We in Colombia didn't speak about statelessness. It's only after 2015 that we started to see an increase of human mobility because of the situation in Venezuela, but also an increase of the crossing through the Darien Gap. As you may know, Colombia has been a country of expulsion due to our internal armed conflict, but we are now also a country of transit, but also a country of asylum. We are receiving not only people coming from Venezuela, but people with many different nationalities. And among those refugees and migrants, there are many people in need of confirming their nationality or even at risk of statelessness or stateless. Therefore, the Colombian institutions, such as the National Registrar's Office, several UN agencies, and civil society organizations started to identify the different types of cases and problematics and thinking outside the box to find alternative solutions for these problematics. So I'm going to talk a little bit about the legal framework. The right to nationality in Colombia is embedded in the political constitution of Colombia of 1991. that says that Article 96 says that the Colombian nationality can be acquired by birth or by adoption. So by birth is like usually Colombian natives who are born in Colombia from Colombian parents have the right to the Colombian nationality, but also children born in the country of foreign fathers. But if those foreign fathers comply another requirement, that is domicile. This is rare in the countries of the region. They usually accompanied by another requirement, but we have it here. I'm going to talk about it more later, because that's the reason, the whole reason of the measure Children First. And we also have jus sanguinis, children of Colombian parents born abroad can go to consulates or embassies from Colombia to be registered as Colombians. And the other way is by adoption, so naturalization processes, including stateless, and two other situations that we are not going to discuss right now because they have these different problematics. Besides the main tool or legal tool that is the Constitution, we have also Law 2332 about nationality, is fairly recent, of 2023. And it states that the domicile implies that the parents must have the will to stay in the country according to the civil code. So that means valid visas, not like transit visas or tourist visas, or even the safe conduct that is provided to asylum applicants until they have this situation resolved, and least of all, people in an irregular migratory condition. This law establishes that it's a valid visa for more than 3 years, and it also includes temporary or special migratory mechanisms like the PPT, that it's the temporary protection permit for Venezuelans. It's a permit for 10 years to stay in the country, and that this document also proves the domicile. But as you can see, outside of these visas and this will to stay in the national territory, we have, or we had at the time, Venezuelans in an irregular migratory status that didn't comply with this domicile requirement. So the children they had in the country were at risk of statelessness. So in 2019, the government, mainly the National Registrar's Office, our immigration office that it's called Migración Colombia, and the MFA, alongside several UN agencies such as IOM, UNICEF, and UNHCR, and civil society organizations started to realize the risk of statelessness of these children of Venezuelan parents born in Colombia. So in an effort to justify an exceptional constitutional change, since I showed you before, the domicile is a requirement embedded in the Constitution. So the government diagnosed this problematic and found out that more than 25,000 children could be affected and didn't have at the time any nationality at all. So these children were indeed registered. They had their birth certificates, but at the end of the document, there was a note, an annotation saying this document doesn't prove nationality. So even though they had the ID document, they didn't have a nationality. It is key to explain that these children born from Venezuelan parents have the right to the Venezuelan nationality, since in Venezuela it applies jus sanguinis. But at the time, the diplomatic relations between Colombia and Venezuela were suspended. So consulates and embassies from that country were closed here in Colombia and pretty much in all the region. Therefore, their parents couldn't go there and register their children as Venezuelans. Also because many of the people living the country or living Venezuela at the time were considered refugees under the Cartagena Declaration. They couldn't go back to their country of origin to register their children. And even though if the consulates and embassies were open, they couldn't go there for fear of persecution. So this was this great risk identified. Another justification of this measure and the exceptional change in the constitution was Colombia's ratification of the 1954 convention and the 1961 convention. And also at the time, several commitments acquired in the framework of the GRF and the high-level segment on statelessness in 2019. The first measure, or there is only one measure, but it was issued in two resolutions. The first resolution was issued in January 2019. It's the resolution 8470 with a validity of 2 years. The measure was renewed again in 2021 and likewise in 2023. The measure this year in August will expire. So UNHCR now is promoting its continuing or its extension since the conditions haven't changed that much. We have right now several consulates, Venezuelan consulates in the country, not that many as we have before, and the procedure is still a bit slow, so we consider that it continues to be a risk for these children to not be recognized as Colombians. The measure is really successful. As of December 2024, more than 114,000 children have been benefited from it, so they have the Colombian nationality. And just to finish, to explain a little bit of both resolutions. As I mentioned before, there is only one measure, Children First, but it's divided in two because it's a temporary difference. So the first one, 8470, it states, and they are both resolutions issued by the National Registrar's Office. They both state that it's a temporary and exceptional measure since, like I mentioned before, it changes a little bit the constitution, and it only applies for a specific situation, only for children born in Colombia from Venezuelan parents. The first one benefits children in retrospective, so it benefits children born in the country since 19th August 2015. And it only benefits children from both Venezuelan parents or if they are a single Venezuelan mother or father. The second...
You're running out of time.
Yeah, only just to explain the last one. The resolution 8617 recognizes birth certificates also authorized by indigenous authorities only for communities living in the country, and it has an automatic extension if at the end of the 2 years the conditions persist. Thank you, sorry.
Thank you very much for that, Laura. We got to learn what it's like in Colombia, and it was good to look at some good practices as well and what countries are doing. And we move on now to Georgios, who serves as a lawyer and legal advisor at Meta Drasi, where he provides legal support to unaccompanied minors and engages in advocacy initiatives. He will speak on challenges related to identity registration and documentation in displacement context, with an emphasis on Greece. And he will provide an overview of the local legislative framework. Over to you, George. we see your slides and you can start now. Thank you. You need to unmute yourself.
Apologies.
I
Thank you
can hear
very
you now.
much.
Thank you.
Thank you very much, Bina. I'm very happy to speak in that very interesting webinar. I would like to provide some observations as well as some challenges through the experience we have gained as metadrasy from the situation in Greece, both in relation to the registration of the asylum seekers and refugees, as well as the general legislative framework. I don't know if my presentation is visible.
It is. It is.
All
But
right.
thank
Just
you.
a few words about Metadrasy. Metadrasy is a non-governmental humanitarian organization that is operating since 2010 in various fields, having as its main aim to provide support in the reception and integration of refugees through implementing innovative activities to cover essential gaps. Metadrasy is a member of the Family of Every Child Alliance. Just to provide the context, Greece is a country that has received several thousands of refugees and migrants through the last years. Based on UNHCR, in 2024, more than 54,000 sea arrivals and 7,700 land arrivals were registered, a very large proportion of whom were in need of international protection, and many have already been recognized as refugees. Among those, several hundreds are unaccompanied and separated children. As of the 1st of February, more than 2,500 unaccompanied separated children were present in Greece. Greek legislation upholds the principle of international human rights protection and has signed and ratified most key international and regional human rights treaties, including, of course, the Convention on the Rights of the Child since 1992. Now, when it comes to the registration of refugees and migrants arriving, according to the Greek legislation, this is mostly based on the documents they already possess from the country of origins, namely the national passport or travel document or the ID card. And as an exception, children born in Greece are identified based on the information on the birth certificate. However, this is the exception. In most cases, people are not in possession of those documents. So in lack of those documents, they are registered based on the declaration of the applicant himself or herself. Also, along with an assessment in some in certain aspects, such as nationality, from the staff. Those information may be corrected at a later stage based on those documents in case at some point people are in possession of the documents, or if it is substantiated during the asylum interview or even at a later stage that for some reason they were incorrectly registered. Also, there is, of course, a procedure for age assessment in case there is doubt on whether an individual is or is not an adult or a minor. There are no specific rules in relation to how minors are registered. In practice, we have observed that minors, especially those of a younger age, are registered based on the declarations of the relatives or of the parents, of course, that accompany the minor, or the minor himself or herself, if he or she is in a position to provide his or her personal information. There are, however, cases where, especially for very young children, there are doubts on the identity, so even a DNA test might be conducted in order to verify that the person accompanying the minor is actually a parent or a relative. Asylum seekers and refugees are issued certain identification documents based on the Greek legislation, which are respectively the asylum seeker cards and the residence permits. Also, the travel documents for refugees. Those documents reflect the personal information that have been registered for the person concerned and are used for all purposes before the Greek authorities. Normally, there are exceptions in the legislation where other documents from the country of origin should be submitted even for the naturalization procedure. Then only the documents that have been issued by Greece as the country recognizing the person as refugee are requested, namely the ID card or the decision recognizing the person as a refugee in line with the provisions of the Geneva Convention of 1951. However, we have observed that there might be some challenges in cases of inconsistencies between documents from the country of origin of the refugee and the data recorded by the Greek authorities, especially in cases of family reunification or in some cases in procedures to recognize some academic records. Another chapter is the birth registration system in Greece and the way birth certificates are issued. According to the Greek legislation on the registries, all births taking place in the Greek territory have to be registered before the competent registry office. The registry offices are operating in each municipality in the Greek territory, and this irrespectively of the nationality of the mother or the parents or the possession of the identification documents and the type of residence permits and the status in general. Even in case that the mother is not in possession of any identification documents, and there have been such cases, there is since 2018 a certain procedure to be issued some temporary documents in order to be able to be discharged from the hospital along with the child. The birth registration certificates include, among others, the date, the time, and the place of the birth, and the names of the parents, which is particularly important, as I will also mention in a while, in relation to acquisition of the Greek nationality. And there are also some ways to register at a later stage the birth in case it has not been initially registered. This is through some administrative or even judicial procedures, and there are such cases. We have observed, especially among the Romani minority in Greece, that there are some births that are registered even decades after the person has been born. There are also some provisions in relation to the foundlings in order them to have both identification documents and an identity. There are legal provisions according to which a certificate is issued for the foundling that includes all information in relation to the identity of the child, if available, and the circumstances that it was found, and the registrar provides a name, a surname, a father's name, and the mother's name to the foundling so that there will be a full set of personal information for the later life. But it has to be noted that such cases are very, very rare in the last decades in Greece. When it comes to acquisition of Greek nationality, and this is closely related to the issuance of the birth certificates, the Greek nationality legislation in general is based on the jus sanguinis principle. Most Greek citizens acquire Greek citizenship based on the fact that they have been born to a Greek parent. However, for more than a century, there have been exceptions in line with the 1961 Convention for Reduction of Statelessness, aiming to prevent statelessness. According to those provisions of the Greek nationality legislation, children born in Greece not acquiring any other citizenship by birth, or those being of unknown citizenship, which might be cases of foundlings, do acquire Greek citizenship by birth. In practice, however, there might be some obstacles and some challenges, not that much improving that the birth did take place in Greece, because this is normally proven through the birth certificate, but the fact that the child does not acquire any other citizenship. And also in cases of foundlings, there might be challenges to prove that the birth did actually take place on the Greek territory. Most importantly, in cases of foundlings not of so young age, or some months or so. And as a final note, when it comes to destroyed registries, there are actually provisions in relation to the reconstruction of the registries. Although those are not relevant anymore, all registries have been fully digitalized. There are physical archives, which, however, can be replaced in case for any reason they are destroyed. However, some historical archives might be critical in some cases, and actually during the Second World War and the period that followed, there were cases of registries that were actually destroyed. So thank you very much for your attention, and of course I'm at your disposal if there are any questions.
Thank you very much, Georgios. It was good to get that explainer from Greece. And here we have the moment we've been waiting for. Benoit van Kerbillik is the director of the Belgian section of Defense for Children. He is also the chief editor of the Journal of Children's Law, in Belgium, and a member of the advisory board of the UN Global Study on Children Deprived of Liberty. But before that, let me tell you, he's a very important person. He is a member of the CRC committee. So let us hear from the expert now on his reflections of the discussion so far. Thank you.
Thank
Over
you,
to you.
Bina, and hello everyone. Thank you for your kind words. You know, I think that we are all experts of our, and we have all our particular experience in that field, and we have heard from several persons who have a concrete experience and showing how difficult this topic is and how important it is. I will not enter into all the details and repeat what others have said, but just let me tell you that, of course, the Committee on the Right of the Child is very much into looking at the situation of the right to identity within the dialogue with the state parties. In all our mandated activities, would it be the reporting process, of course, individual complaint, or the inquiries that we can also conduct, but also in our general comments, and we have reference to the right to identity in several general comments. So this is just to set the scene. The committee has, of course, always given an importance to this. When any states come to us, we will look, and this is part of the structure of the dialogue with the states, we will look at, of course, the legislation, the rate of registration of children, whether they do issue birth certificates, if those include all dimensions of the right to identity, name, nationality, family relation, and so on. And we really try to identify all the risk and to prevent all violation of the right of the child when it comes to lack of identity. And we have heard many examples of such situation. Among others, it has been said, but we have to make it and to repeat it over and over again. The birth registration has to be free of charge, including in an extended period, because very often we can see that the registration hasn't been made at birth or in the weeks after birth. And so there is also the need to recover and to establish the identity of the child later on, and this has also to be free of charge. But it's not only, not asking any fees for registration or for the delivery of the issuing of the birth certificate, but it's also for all the global context. We have seen in so many examples that there are fees that are asked for other kind of services that the state is putting in place. For instance, one state was asking fees for the paper on which the birth certificate was printed. They claim that it's free of charge, except for the paper and the ink that is needed to print it. So sometimes you see we have to fight against all those concrete and simple examples. We also have to fight against corruption, because we know that there is a high level of corruption in many states, and this is a possibility when you know that you need this birth certificate to reach out to some services from the state. There is a risk of being corrupted to obtain this kind of document. So we ask all the states to remove all obstacles, financial barrier, but also to recover the identity later on. We ask states to identify the gaps. Very often a part of the population will have more difficulties to register the child. We have heard about internally displaced person, minorities, indigenous people, but also vulnerable population, migrants, and so on. These are more at risk of being denied the right of identity. But it's also an obligation of states to ensure proactively that all children are registered. It's not enough just to say we are sitting on our chair in the office and waiting for people to come to us. There is a need to go to people and to facilitate and to ensure that everyone will be registered, and even if it's later on. We have a good example of that. Sometimes the court is moving from one place to another to ensure that children who haven't been registered in the past can be registered later on. And sometimes we have also example of, for instance, services like access to school or other services have the obligation to ensure that when a child is asking for attending school or receiving any kind of service, if he or she doesn't have any birth certificate or any identity document, it is the duty and the obligation of the school or another service to ensure that the registration is done, and that the child will recover his or her right to an identity. We have other such example where there is a support from the state, support from other services to ensure that this is done. The mobile application and is another good example, and that was mentioned by some of the speakers. In two cases, at least in the context of individual complaint, you know that we can receive individual complaint from children or their representative. We had to look at the situation of the right to identity. For instance, for children who wanted to be to attend school in Melilla, it's part of Spain in the north of Morocco. And they were just refused to attend any school, official school, because they didn't have any official document, nor identity document or identity or birth certificate. They came to us, and we have asked Spain not only to ensure that all those children would be able to go to school, but also to help them to recover all the dimension of their identity, and also to ensure that this does not happen again. This is part of the remedies to avoid the repetition of the violation of the rights of those children. After this decision, we were pleased to see that Spain has put in place a system that guarantees all children born in the or living in that region were able to attend school. Another example is the age assessment of migrant children. We have received several complaints from different children in different European countries, mainly, that were complaining that when they were assessed as migrant children, they were considered as being adult and excluded from all the services, and we have heard what's happening in Greece. And that's, of course, a very, I mean, it has a lot of consequences on access to all the rights, protection, support as a child. And very often there is no remedy in place, or the remedies are very lengthy procedure, difficult to access without proper support. So when we see all this example, we understand that there is a need to ensure that there is also remedies in place, and this is why the committee is now working on a new general comment on the right to access to justice and effective remedy for all rights, all violation of children's rights, but including, of course, the right to identity. What we mean by access to justice, it's the ability for a child to obtain a just and timely remedy for any violation of his or her rights, and that it has to be done through avenues that are adapted for children. And when it comes to remedy, it's both the process to claim a right, but also the outcome of the process, and to ensure that there is a reparation at the end and a cessation of the violation. So in this general comment, we will address many different dimensions. I will mention a few of them. The availability of the remedies. So very often there is just no remedy in place. And so we need availability, we need that it exists, we need to ensure that children are, and families, of course, the ones who are representing and supporting the child, are aware of the existence of those remedies. But those remedies have also to be accessible. Accessible, that means not too far from the place where people are living, but also accessible in the way that there is no such many conditions to access to it, and to be able to be heard and to access to the service. Those remedies have to be adapted to the child. One of those conditions is timeliness. Of course, if the time passes on, the child will be denied many of his or of her rights before receiving any identity document. That means also access to information, child-sensitive communication, multidisciplinary and coordinated support, and an adapted environment globally. The remedies must also be effective and aimed to achieving a concrete redress. So that means also that one has to see what kind of rights have been violated, what are the consequences of those violations, and whenever it is possible, we need to ensure that there is a restitution of the rights. So re-establishing the identity is extremely important. If the violation of the rights had some consequences, there need to be a compensation, and the possibility to recover and reintegration all the consequences of the violation of the rights. There needs to be also a guarantee of non-repetition. So that means also that the state, once they have identified that some children do not benefit from their rights because of the lack of identity, they should benefit from a support that this will not happen again. And finally, all the remedies and access to justice needs an enabling environment. This is how we call it. So that means, of course, that human rights instruments have to be ratified by the state. The legislation has to be in place. That there is enough resources and budget to ensure that this right can be put in place properly for all kind of population and children. There need to be also an independent monitoring that oversees the services that are in place, can identify the gaps and also address all those gaps. Very important, we highlight the importance of the cooperation with the civil society and the UN agencies. We have also heard example of the role of both of them, because we know that for many people, even if the services are there, their access to those services may remain difficult without a proper and adapted support. And then globally, of course, in general, we need child right education, training of professionals. Training of professionals is probably also extremely important in that regard. And finally, don't forget the importance of data collection. We have heard a figure by the previous speaker. We can see that there is a big disparity between states, but there is usually a lack of data and accurate information about the birth registration and the right to identity globally. So we hope that through this general comment, we will be able to support all initiative that is working in view of putting in place and guaranteeing the right to identity for all children, that states will be encouraged to ensure that there is a remedy in place and access to justice for all children, and that the gaps and violation that we have mentioned during this webinar are addressed through a proper channel. So just a last word on the next step for the process of adoption of this general comment. We have, during our last session, we have adopted the first draft. After a first round of consultation, we received more than 300 submissions. There were several expert meeting consultation, including consultation with children. And with all this material, we have finalized this first draft. And now there will be, from the 1st of April for 3 months, a second round of consultation based on a first draft of the text. So please have a look at it, analyze this draft, and provide all your comments and suggestions on how to improve this general comment to make sure that this will be useful to address violation of children's rights in general, and in particular the right to identity. So this is it for me, but I'm open for any question that you may have. Thank you.
Thank you so much, Benoit. And those recommendations were so robust and so wholesome. And I'm sure that many of us here can actually put them into practice. I'm going to answer. So if there's anyone in this room, please address your questions to the panel speakers, and we'll be happy to respond to the questions. I'm going to take the question now, which is oh, hold on, which is birth registration for minority children in Cambodia remains critical and no solution, since the government has no commitment in addressing it, how to deal with it effectively. Perhaps I can just, as a moderator, I'll take this privilege to respond how Malaysia and Malaysian civil society got together to actually improve the situation with regard to citizenship. There have been a lot of in the previous years, there was a backlog of citizenship applications. And we heard, like, back in 2023, there were about 150,000 citizenship applications. This was an issue that was not talked about much um, in the earlier days. And what happened was civil society organizations actually got together, many of them, and started discussing the issue, starting putting up articles in the media. And then it was a multi-pronged approach that was used, especially that I can tell you what Family Frontiers did in Malaysia. We put up questions in Parliament. We made use of Parliament mechanisms like the parliamentary select committees. We had briefings with MPs. We also got the impacted persons, the children. Actually, we told them about the Child Rights Convention, and they started realizing how it was impacting them and what were the rights that were being violated. And so on one of the Human Rights Days, the children went there and recited what was their rights, what were they being deprived, and that was very powerful. So out of this was the media. So the media really got stories of the adults, the mothers. The mothers came out themselves and took the advocacy upon themselves and started speaking to MPs, started speaking to the media, started speaking on national television. The issue became really something that people started talking about. So we got collaborators, young people who came out in full support. And as a result, the government has given a lot of commitments. Happy to tell you that Family Frontiers also was able to get an amendment in the constitution to enable children born to Malaysian mothers overseas to acquire citizenship. But it was not done retroactively. So there is still a lot of work to be done by us. But really, the power of advocacy, the power of the impacted people, allowing agency to the impacted people, to the young people who don't have citizenship, has made a difference in the advocacy program that we have in Malaysia. So thank you for this time as well. And now I'm going to have there's a question here, which is for Benoit from Raju Kimri. It is nationality or identity is a global problem, especially children abandoned by parents and guardians. What is the best solutions, as governments don't provide us with the solutions? Over to you, Benoit, to answer this question.
Yeah, so I think that you refer indeed to the need to have some remedies in place, and obviously the situation that you describe is a violation of several rights of those children. Concretely, that means that there should be remedies, either judicial avenues, a judge that can take a decision, take a decision on individual situation. But sometimes, and this reminds me of the need to address issue collectively. Because when, in many cases, when there is a violation of the right to identity, one child or one family alone won't be able to address this situation, especially in case of, as you mentioned, Bina, a situation where the constitution or the law itself is the problem. And so for this reason, I think that it's extremely important to have also collective remedies. So remedies that could be used by civil society or lawyers or collective of people who wants to fight for a specific right, access to justice for civil society to address one collective problem is also extremely important. And because it requires legal capacity, financial capacity, very often a long time, and all this can only be put in place when there is enough means accessible. And so, yes, I think that very often these rights do not, it's not only the problem of one child or one family, but it's the problem of a group of persons. Yeah, having also in place an independent ombudsperson for children or independent human rights institution that can take such problem, identify, measure a problem, and address it through the right channel to the government, parliament. Members of the parliament can also be sensitized about the problem, and that means that they could then play the role and propose a modification of the legislation or things like that. So this is, I mean, globally, right to access to a remedy. It's not only an issue of individual remedy, but also collective remedy. That is, for me, very important.
Thank you for that, Benoit. I hope that answers the question. So now I want to ask all the speakers here one by one, if you would switch on your camera so I can ask you the question. Georges, I'm going to put you on the spot and ask you if you could recommend one concrete action that policymakers, UN agencies, or civil society should prioritize in the next 2 years. What would you recommend?
I'm afraid I'll be a bit generic, but I would say coordination on setting a minimum of standards that could be implemented worldwide, along with provision of resources to the poorer countries, both as technical and as financial support in order to implement such policies and address the issues discussed.
Zoe, what about you? Do you want to recommend some solution to the issue that you brought about and you spoke about? What could countries do in the situation that you mentioned?
Yes, thank you very much, Bina. Yeah, it's probably a bit generic, but just the fact to take into consideration the specific situation faced by children born of rape when developing policies it's critical. That making sure they are not left behind and that their specific needs are addressed. As mentioned, targeted interventions are key. Even if broader interventions work, they need also specific and targeted intervention. But if I have to choose one concrete action, that would probably be to remove the requirement of a legal identity as a prerequisite to access other rights. That seems like the easiest action that states could take, and it will really ease the situation of children born of rape. The fact that they could just access justice, they could access remedies without a legal identity, they could go to school, have proper education, have access to healthcare. That would be a first step. Obviously, that won't solve the whole issue, but that's concrete and that's easy enough. Just don't ask for legal identity to access basic human rights that have been recognized in international human rights law. Yeah, that's it. Thank you,
Karen,
Mina.
and I'm sorry if I put you all on the spot, but Karen, what was that one policy reform you would like to recommend to states, given the situation where child's lack of access to a child's right to identity?
I mean, we're seeing that they sometimes take quite a bit of time to put in place, but the policy review, the policy adjustment is really critical to simplify the processes, but also to ensure that they are accommodating and inclusive of all populations within a particular territory. And I saw that there's also a question related to an African Union protocol, and I would definitely will come back on that. But I think one important thing about that is it does mention the birth certificate and the importance of the child having that identity, which I think is critical. And what I think is really exciting for Africa is also that there's an MOU between the Committee on the Rights of the Child and the African Committee of Experts on the Rights and Welfare of the Child. So it provides an opportunity to bring in all of these global contexts into the work in particular contexts. And I think that would be something that what I would hope that this particular protocol would also be looking at. And I think one of the reasons why the general comment is so important, because we're always finding ways in which legislation and policies and MOUs can be done to help temporarily or longer term get rid of a bottleneck or a block. Thanks.
Thank you, Karen. Laura, I'm going to ask you now, what do you think was most effective in the situation that you spoke about with regard to the Venezuelan, with children born, children born in Colombia? What was most effective there in that, given that situation?
I'd say, Bina, to just is a common place also, but to think outside the box, you know, it's not impossible to make a change in the law, to make a change, even if it's an exception to the Constitution, to tackle a specific situation, and based also on the protection of the rights of the child. But also in Colombia, it was really important, the joint work, an interagency work and an interinstitutional work. I think the views of different institutions, organizations, agencies was key to have this as a result, the measure.
We have another question in Kenya. A child found abandoned and is estimated to be less than 8 years old, 8 years, and parents cannot be found, identified due to, after due diligence, are treated as Kenyans and will be citizens. So I guess this is really a good practice. And I wish there were countries who would follow that, because sometimes it is not the case in Malaysia, where the state takes a long time to actually approve some of the citizenship applications. Some of them age out, and literally we've come into contact with children who are stateless and say, we are invisible. We are like ghosts in this country. We need rights. And then it's really important that states take cognizance of this, and really no child should be deprived of its nationality. And so are there anyone else who has any other last comments before we go into the conclusion? Okay, so then I just want to say thank you to everyone who has been here. We had 112 participants in this discussion. The recordings and resources can be found on CHIP website. Also, the first and second recordings of the webinar 1 and 2 are also available on the website. And if you found this webinar interesting and insightful, don't forget to register for the 4th webinar on 4th of March on the right to family relations and access to justice and effective remedies. And to our distinguished panelists, I really want to say thank you. And a round of applause, really, and thanks goes to CHIP for organizing this webinar. And as we conclude today's discussion, it is clear that the right to identity is a foundation upon which all other rights rest. And without legal identity, children remain invisible, vulnerable, unable to access basic services like education, healthcare, and protection. Our speakers have highlighted the urgent need for a robust CRVS system and a critical role of international cooperation, innovative solutions that ensures that no child is left behind without an identity, especially in times of a crisis. From conflict-affected regions and to migratory contexts, we have seen how access to legal identity can transform lives, restore dignity, open doors to justice. And these conversations must translate into action. Governments, civil societies, international bodies must work together to ensure that every child, regardless of the circumstances, is recognized, protected, and given the rights they deserve. So I think one of the asks of civil society organizations is there needs to be more resources available for them, including funding. Affected persons need to have the agency and be brought to the decision-making table. And initiative needs to be made by each person, each of us in this room has a duty to continue to push for the legal identity because every child matters and every child deserves to exist legally in the eyes of the law and in the world today. So I really want to thank you all for joining us. But if anyone has any last words, would you like to say it? Would you like to speak up? Please feel free. We still have 6 minutes left and we are in good time. Anyone? Mia, do you want to say something about all the work that you're doing at CHIP? And really, we need to thank CHIP for putting this this webinar and the series of webinars that have been put up by you and the organization. I want to thank especially the Identity Rights Working Group, co-chaired by Child Identity Protection. I just know them as CHIP. I love the name. And the Institute of Statelessness and Inclusion. So this was a follow-up to an expert meeting conducted sometime in June of last year, and it brought together several members of the Committee on the Rights of the Child, representatives of UN agencies and non-governmental organizations, academics, and persons with lived experiences. So there's a 4-part webinar series, and this was the third of it. And I'm going to give some time to Mia if she, wants to wrap this up. And so thank you, everyone. Participants, you've been wonderful. Panelists, thank you for all your recommendations and solutions you gave to us. Over to you, Mia.
Thanks, Bina. I think I'm going to leave the floor with Benoit because there was one question and I didn't see that it was really answered, but I'm going to put you on the spot. It was a question raised by Bronwyn. And it was, what are the possibilities for the CRC to prepare a general comment on Article 7 and 8? You knew I was going to ask, Benoit. So I give you the last word.
Yeah, thank you, Mia, and thank you and also for Chip and your great work and for pushing continuously on this. So as I answer in the chat, we work only on one general comment at the time. And so we will be very busy until next year, somewhere in January, February next year, when this general comment will be published and finished. And at that time, of course, we will work on the dissemination and ensure that it's known and it's used, because otherwise it remains, on paper and not fully implemented. And so, first of all, I would say, let's use the existing tools. So that's for my first suggestion and recommendation, because we have already many tools in place. We have also, and please don't hesitate to bring to us individual complaint or requests for inquiries. Of course, if the state in question has ratified the optional protocol on individual complaints. But as you have seen, we have been looking at that and we have been addressing this issue through all these means. We have already several concrete recommendation in other general comments. So we have already several tools. So now I cannot say for the next general comment, because this is a decision made by the whole committee. But of course, if there is a strong argument, and I can believe that there are many people who can help us to make a strong argument to have a general comment on that topic, this could be looked at very closely. Of course, as you can imagine, many people are really pushing us to adopt general comment on many different issues. So, we can, of course, think of this topic as one of the important ones. But my message would be, don't wait until this is done at the end of of the day, but start by using the existing mechanism in place. And this will also inform any piece of recommendation, whether it be a general comment in the future, because we, as much as we have on the topic, as good as we can deliver a document, including, you know, when, and those examples that have been mentioned from different states, please send us, most of you do that, and Chip is doing that very well, but send us reports, sometimes very concrete information that will help us to put very concrete and effective recommendation to states. I have heard many things today, I took note, but when a state comes to us, we need to know what is happening in the field, and you are our eyes, you are our ears, and we need this in order to support you in your work through our recommendation put to states. So this would be my recommendation. I know that I haven't answered completely your question, but continue for, pushing for that. And but in the meantime, we continue working on it through different other channels. Thank you.
Thanks for that, Benoit. And it is a real honor for all of us to continue working with the committee and providing you with that information. And you can be assured that the Identity Working Group will continue to do that. And so maybe then we can finish, we can be very Swiss here. It's exactly 2:30. Thanks again, everybody, for joining. Thank you for making the time. Thank you for the panelists and also the participants. Everything will be on the website, and we look forward to having you all with us at the 4th webinar. Have a good rest of the day. Bye.
Bye-bye. Thank you.